item number 8.
Yes, my lord.
Review.
Yes, my lord. No, government advocate is not here, so myself also.
Government advocate is not required.
On 29th, it may be fixed, my lord.
Mr. Hajarika, it's your case.
Yes, that is my case, my lord. Today, myself also not feeling well. That is the reason of it. And moreover, he is also not.
See, the last time around, I had requested the parties, in fact, the managing committee,
Yes, my lord.
to see if there is
A settlement possible.
any possibility of settlement.
Oh, yes.
Um,
No, they are not in a mood to settle the matter.
so we'll finish it off.
Yes. Oh. Oh, I got the respondent.
You're in this case.
Lordship, I'm appearing on behalf of Mr. R. Guru.
So where's the petitioner then?
Petitioner not here, my lord. We will inform him. We will inform him.
Petitioner is absent. However, Mr. A.H. Hajarika, learned counsel for the private respondent, has submitted that this matter may be heard on the next date as he is not keeping well. On premier, release this matter after 1 week.
Yes, most of it.
Please, Your Lordship, I beg to mention item number 3, Your Lordship. I prayed for 3 week times.
We have very less matter. You cannot just, the court cannot just sit for 5 minutes and then.
Conducting counsel is not to some personal difficulties.
What is the matter about?
The service matter, Your Lordship.
On pre-made by the petitioner, this matter after 2 weeks.
Your Lordship, if kindly allow 3 weeks, maybe it fix after the 15th of September, Your Lordship, because the conducting counsel will be out of station.
3 weeks.
Obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 6. I'm appearing on behalf of the respondent, my lord. The petitioner is on.
Well, I am appearing item number 6,
Oh, yes, Dr. Saraf. So,
well, there is a amnesty scheme floated by the government, and in fact, the petitioner applied for it, but the matter is pending. So, I would pray that the matter may come up after 8 weeks, so that in the meantime, if the amnesty scheme, my petition is allowed, then the matter will be withdrawn. But if it is not allowed, then I have to proceed with the case,
how long is it?
Well, the amnesty scheme is being floated, and I have applied for it. But the decision, the government will have to take it, and the last date is for December. So if the matter is adjourned for like 6 weeks or 8 weeks, then we can await the decision of the government whether they accept my amnesty scheme application or not.
Okay. We'll keep it for 4 weeks, then we'll see how it goes.
My right, Your Lordship.
On pre-made by the Dr. A.K. Saraf, learned senior counsel, has submitted that there is a scheme floated by the government related to the subject matter herein, and the petitioner has applied for the benefits of such scheme.
So the amnesty scheme, amnesty scheme.
Amnesty scheme or amnesties.
Right.
If and when the said scheme is allowed in favor of the petitioner, then this petition would be rendered infructuous. However, in the meantime, until the result of the said scheme is known, it is prayed that this matter may be adjourned for the time being. On prayer meet, the same is allowed. This is matter after 4 weeks.
I'm playing.
4 weeks.
Much obliged, Lordship.
Please, Your Lordship, I beg to mention item number 5.
Why?
Lordship, I
What's,
bring that this matter may come up in the next.
I'm ready, otherwise, sir.
what is this matter about?
Promotion matter, Your Lordship. Promotion matter. The petitioner was denied of.
Yeah, promotion. We should finish it off as soon as possible. It's a 21 matter.
The Contempt Council is having some personal difficulties, Your Lordship. It's having parted matter in code number 1.
On prayer by the petitioner, this is matter after 1 week.
Yes, Your Lordship.
1 week.
I'll oblige.
Please, Your Lordship. Lordship, I beg to make a mention item number 8.
8.
2 weeks, Your Lordship.
Fine. You don't need to mention this. Already been mentioned. In anticipation of your asking for adjournment.
From supplementary cost list, item number 1.
Yes, Mr. Sheikh, tell me.
Matasaji is not here, so let the matter be at the bottom of the list, Lordship. Let him, because I don't want to do hearing in his absence. He will be coming.
End of the board.
Lady cost list, item number 1.
लिख दी गई हूँ
Lordship, I'm required to file my rejoinder. Some personal difficulty on our part, Lordship. We cannot. I'm praying for some accommodation.
That we bridge matter.
Lordship,
Is it that we bridge matter?
the check gate.
Check
Lordship.
gate. Check gate. You're enjoying interim relief.
Lordship.
So
Lordship,
if you're not keen, then that
Lordship,
order will be vacated.
Lordship, within a week's time, we'll file. Within a week's time.
Leonard, Leonard counsel for the petitioner has submitted that the rejoinder to the affidavit, counter affidavit filed by the state could not be filed today and has sought for some time. As prayed for, this seems allowed. This is matter of 1 week.
Hello.
Item number 2.
My lord, the respondent number 7, they have filed the affidavit. So I pray for 2 weeks to file my rejoinder.
Why 2 weeks?
Yes.
And for number 6, Lord, I require another sponsorship.
Oh, you have not filed yours? Mr. Ganta?
I'll file after some time, maybe 2 weeks, Lordship. We are ready with the affidavit.
All the respondents except the respondent number 7 has yet to file their counter affidavit, and as prayed for by the learned counsel appearing for the respective parties, the counter affidavit is to be filed within the next date fix. This is matter of 2 weeks.
Much.
My lord, my prayer distinct for my rejoinder also be reflected. I'll file.
No, you should let them file, and if you want to file the rejoinder in the meantime, you can always do it.
Mashallah.
Item number 4.
May please, Your Lordship. My Lord, this case pertains to the equal pay for the equal work, my Lord. We are members of the association, my Lord. The case has been represented by the registered association.
Regular or contractual?
My Lord, we are long-standing casual workers, my Lord. We are doing a regular job.
That doesn't solve your problem. If you are contractual, means you are contractual.
My Lord, we are a long-standing contractual
whatever.
but doing the same, my Lord. The same nature of work, the same risk, but we are not being paid. We are not being paid the minimum of the pay scale that is the law is settled in that, my Lord. There's a few judgments are there. Jagdish Singh's would be
minimum pay scale.
My Lord, yes, my Lord. Minimum scale, my Lord, because you are taking the same risk. We are the employees, my Lord, the casual employee, the employees of the MEECL, my Lord, and some of us we retire on superannuation. Of course, we don't get the benefits as the regular people are getting, but there are notices which says that you have served this many years, it's time for superannuation, you go and retire. We retire after serving the entire youth's entire energy that we have given, then we go we retire. So, my Lord, basically the equity, the jurisdiction of the equity will have to will plead also in that, my Lord.
You know very well, equity of course would come in,
my Lord.
But you have to also look at these this involve policy matters.
My Lord, kindly look at one. Just wanted to show.
I'm sorry, Your Lordship, if I may interject, Your Lordship. The answering respondent is not present right now, Your Lordship, which is MECL.
You are appearing for?
I'm appearing for the state, Your Lordship. We have no role in the matter. However, the answering respondent in this matter will be MECL, Your Lordship. And
yes, who's appearing for?
Mr. Surya used to appear.
Sahi, Your Lordship. And he doesn't seem to be online
Mr.
also.
Shurya. He used to appear with Miss Rosie.
Miss Colney is on legs, Your Lordship, in court number 1.
So let it come. If that be the case, then what do you say?
At the end of the board?
At the end of the board, or some other date also is okay. Yes, it seems that
1 week.
1 week, my Lord, 1 week.
On payment by the parties, this is matter to 1 week.
1 week.
Obliged, Your Lordship.
Item number 7.
Petitioner is Mr. N. Sincon. Last duration of time. May I please, Your Lordship? The conducting counsel is occupied in the other courtroom. Can this matter be taken up after 2 weeks?
It will take him 2 weeks to be occupied there. That will take him 2 weeks to be occupied in the next room. He's okay. We'll do one thing. We'll wait. He may be ready by then. End of the board. What is this matter about, please?
It's a regularization, Your Lordship.
Regularization?
She's already terminated, Your Lordship, and appointment is also made by the MPSC recommended, and MPSC also made in the Thura Polytechnic College, Your Lordship. And not only that, Your Lordship, her initial appointment was temporary, and she was overaged. And an agreement was signed while giving temporary appointment that she cannot file any case or pursue any grievance if she is not regularized. But let her senior be here, Your Lordship. State has filed affidavit on behalf of respondent number 1 and 2. And she is already 33 years while in service. When she appointed first in 2013, she was already 33 years, because 27 plus 5, 32 is the age limit for absorbing government service, Your Lordship. So matter was heard at length in other court. Now fresh it will be, but last date also short adjournment and
Okay, we'll see if Mr. Sinkon is available.
he's available.
Right now he's putting the corner. Thank you.
We'll see. We'll keep it at the end of the board, rather after the next case.
He'll come to next.
You pray. Lordship, can this matter be taken up after 2 weeks?
On prayer made by the petitioner, this matter to 2 weeks.
Much obliged. Second call from supplementary cause list, item number 1.
Where's Mr. Oh, here, yes, go.
But before my friend begins, my lord, I had a conversation with the department, my lord. Now, as far as the tribunal is concerned, my lord, although they said that it's probably there, my lord, but my lord, he requested that if some more time can be given only to, my lord, to give a confirm.
The alternative remedy, you mean?
Yes, my lord.
Whether she has to, take, recourse to
Yes,
such remedy.
because my lord, my contention was that since it is provided in the rules, so my lord, tribunal should be there. So my lord, when I had a conversation, my lord, I was informed that it should be there, but however, my lord, he requested that if some time can be taken just to verify that fact, my lord.
But have you checked from your client?
So far as my knowledge, Lordship, there is no tribunal act, because some of the provisions of the RTA Act, Government of Meghalaya is implementing just now, Lordship, like that NCT norms, Lordship, MTEC. Though the RTA Act was enacted way back in 2009 and came into force on 1st April 2010, but some of its provisions of the Act is implementing now. Now, by way of notification 2020, this year, 2020, Lordship, the section 23 of the RT was implemented in the state of Meghalaya. As a consequence thereof, Lordship, now they have to equal for. So far as my knowledge, what I have inquired from the other sources also, Lordship, no such.
Where is the provision for that, Mr. Sergi?
My lord, it is at the rules which is framed by the state of Meghalaya, my lord. The RTA rules which is based on the RTA Act, my lord. That is, my lord.
Rules.
Yes, my lord.
That is Rule 20, Lordship.
So these rules have come into force since 2011.
Yes.
And your cause of action is in 2016.
16.
Then naturally it should have been there.
But there is no tribunal as of now, Lordship.
Rule 20.
Rule 20.
Yes. The state government shall constitute school tribunals at the state level, which would act as the grievance redressal mechanism for the teachers.
My lord, here the issue is with authority, Lordship. My lordship is sitting in the DB with regard to that one matter that is listed for judgment today. The Justice Honorable Mrs. Thinky has passed the order with regard to the authority, whether that office of profit is applicable to the employees in aided
That's a different
My lord,
thing.
another
Yes.
aspect, my lord. Because my friend has argued that Meghalaya Education Act will be applicable, my lord. But however, even regarding that, my lord, I had sought for some clarification. But in so far the view of the government, my lord, it is not applicable.
As far as SSC is concerned.
Yes, my lord. But however, I will try to get it, get a written instruction, my lord, in order to assist this honorable court, my lord.
Well, Mr. Sheikh, I think you still have to, I think it's not clear from your petition whether this school is, under the SSA scheme or the regular, government aided school.
Under SSA lordship, because in the orders also it says that SSA LP school lordship. Now when although my friend has in the written submission made the statement saying that with the enactment of RT Act and the rules, the SSA has come into play in the state of Meghalaya. That statement is incorrect, lordship. So I have the notification when the SSA is being implemented in the state of Meghalaya. Now there are two aspects, lordship.
Have you incorporated in your?
No, I brought the notification,
No,
lordship, because
in your petition.
no, my lord, I have brought just now. I have, because that issue.
Then if it is a matter, if it is a matter of introduction of new facts, then you have to.
No, this is just notification just to with regard to the what we call that, when the SSA came into force. When the SSA came into force, lordship. When the government of Meghalaya implementing the.
Give him a copy.
Yes, I'll give. This is in regard to that. And my lord, here.
So, my lord, it's even earlier, 2002.
Yeah.
Yes. Not with the enactment of the RT Act and RT rules, lordship. Because then prior to.
Oh, okay.
Is then prior to the RT Act, then whose rule?
Okay, so the SSA's scheme came prior to the RT Act, so it has got no nexus or nothing.
My lord, Sarva Shiksha Abhiyan, my lord, if I may submit, but the basic intention is to provide education to all, my lord. And the same spirit is carried out in the RT Act, my lord, right to education, which makes it compulsory for every child to get educated, my lord.
That's true. But we are talking in the context of having teachers appointed according to the or in line with the scheme SSA, distinct from the other type of employment, like the regular.
They are not regular, my lord. They get a certain lump sum amount,
Yes.
lump sum grant from the government.
That is aided without the sources. My lord, for him.
My lord, as far as the clarity, my lord, because this matter requires clarity, my lord. So, my lord, what I am praying, because it will be good for all, let me get a written instruction from the government, my lord. What exactly? Because even in the affidavit that we had filed, my lord, we had categorically stated, our statement has been through and through has been one, that it's not applicable.
My lord,
the Meghalaya Education Act is not applicable.
My lord, the aspect, lordship, if my lord may come, section 24, under which the rule was made for constitution of tribunal, lordship, here specifically mentioned 24 of the RT Act, lordship. Now, before that, my lord, can I submit the history of the SSA as well as the history of the RT Act, lordship?
Yes.
24A and down, my lord, clause 2, lordship.
Talking about the rules.
No, lordship, this is Act.
Act. Section.
Section 24, sub rule 2. A teacher committing default. This is with regard to the conduct rules, lordship, service conduct rules.
No, you're talking about the RT rules or Act?
RT Act, lordship.
Yes, section 24.
24, lordship.
Duties of teachers and redressal of
yes,
grievances.
Lordship. The sub clause down below, down, lordship. 2. These are the duties.
Okay.
And down, lordship.
2,
lordship. A teacher committing default in performance of duties specified in 1 shall be liable to disciplinary action under the service rules applicable to him or her. provided that before such taking disciplinary action, reasonable opportunity of being heard shall be afforded to such teacher. Now the question, Lordship, I may be allowed to submit the brief history of the RTE Act, Lordship. My Lord, SSA, although launched by the Union of India with a motive, Sarva Sikha Abhiyan, means universalization of education. The main purpose of launching this scheme is to make 100% literacy rate to the citizens of India within the age group from 6 to 14. That means from class 1 to till class 8. With that motive, Lordship, in order to achieve that goal, Lordship, then the Parliament has amended the Constitution and inserted the provision, Article 21A, in the Constitution, and that article came into force on 1st April 2010, Lordship. Then Article 21A say, Lordship, the right to education. The state shall provide free and compulsory education to all the children of the age to 6 to 14 years in such manner as state may by law. So, in pursuance of the constitutional provision, Lordship, the Parliament has enacted the right to act, meaning thereby now right to get elementary education, that is from class to 8, is a fundamental rights. Now that RTE Act, whether will be applicable only to SSA? It has defined the school. That RTE Act defines the school. Schools means school owned by the central government. Schools mean owned by the state government. Schools mean owned by the private. Schools means even unaided minority school also, Lordship. Because the main purpose of RTE is to achieve quality education. And in order to get quality education, then they have to start school with the qualified teachers. That is the main motto. And with regard to the service rules, Lordship, central government LP teachers service rules will be governed by the CCS rules, and the state government LP teachers will be governed by the state government service rules, and the aided schools governed by the Meghalaya Education Code, because here from school to till colleges, the rules are codified in the Meghalaya Education Code. My friend is saying that RTE Act is applicable only to that SSA school. This is not true, Lordship. For a moment, my Lordship, if my Lord kindly come. Definition clause, Lordship, of the RTE Act.
Yes.
Definition clause, that is definition at section 2, Lordship. Now they have defined all. Now, Lordship, the definition N, clause 2, subclause N, Lordship.
Yes.
School, may I read, Lordship?
Yes, please.
School means any school recognized, school imparting elementary education and includes. That means from class to 8, Lordship, elementary. A school established, owned or controlled by the appropriate government or a local authority, that is the state government. An aided school receiving aid or grant to meet the whole or part of its expenses from the appropriate government or the local authority. A school belonging to a specified category. Now, what does the specified category mean, Lordship? Down that the definition is given. A specified category in relation to a school means a school known as Kendriya Vidyalaya, Navodaya Vidyalaya, Sainik school, or any school having distinct. And an unaided school not receiving any kind of aid or grants to meet its expenses from the appropriate government or the local authority. That RTE Act is not governing the service conduct rules of the employees. So far as the service conduct rules of the employees of the school, it governed by the respectives, like central government, LP teachers will govern by the rules framed by the central government, like state government.
Yeah, you have said that.
Yes, Lordship. Pardon?
You have said that.
Yes, Lordship.
So tell
So
me,
now my friend is only specific that only RT rule is applicable only to that SS is not true. This is a guidelines. This is that they want the quality.
The issue here has been raised by Mr. Bhattacharjee is the import of the RTE Act vis-a-vis the Meghalaya School Education Act. So whether there will be a conflict between the two, or whether they can, they can exist side by side, or what will be applicable.
My lord, one simple test, my lord, is that when the formation of a managing committee takes place in the Sarva Shiksha Abhiyan schools, my lord, my friend may clarify which rule applies. My friend may kindly clarify which rule applies.
I'll clarify, Lordship. It's with me, Lordship. My friend is saying
It is applies, the rule which applies is rule 13 of the RT rules.
Only in SSA. My lord, so far as constitution of managing committee, what my friend is saying, rule 13 is applies to all schools imparting elementary education, whether it is a government school, whether it is a SSA school, whether it is a deficit school. I have the constitution of the rules for what you call the constitution of the managing committee, Lordship. I have two constitution, Lordship. For deficit, under the same rules for 2 years. For aided school, under the same rules, I can supply, Lordship. One.
Any document supplied to the court has to be given to the other side.
My contention is not like
This is only formation of managing committee. What does it say?
They have invoked the rule under section. That is why the term is
section 13.
13. Why he is confined only that? And section 24 says, so far as the disciplinary, so far as the conduct, service conduct rules is governed by the respective service rules. They have their own, like government schools, they governed by the Meghalaya service. Because this is not a service conduct rules, Lordship. The conduct rules is different.
Yes, that
conduct rules is different.
My lord, if that is so, then what is the purpose of tribunal, my lord?
Tribunal, my lord. Tribunal, if any action is taken by the managing committee.
No, it doesn't say that. It says any grievance. By the teacher.
Section 3, subclause 3.
My lord, kindly appreciate one thing. Because why that provision is mentioned? My lord, if we interpret nicely, Lordship. Because the appointing authority is the managing committee. So meaning thereby the dismissal or the disciplinary authority is the managing committee. So that is why that if any action is taken by the government with regard to the managing committee, then managing committee can approach to the tribunal. Now if any action is taken by the managing committee against the employees, then he can go to the tribunal. My case is not, the action has been taken by the managing committee, my lord. I am issuing the authority, raising the issue of authority. That since it's a aided school, the management is the ultimate authority for appointment.
But you see, in your case, there was no managing committee.
No managing committee.
So in its stead, there must be some authority, and the government has taken over that authority.
My lord, as far as this,
that is why, my lord.
That
is why I, on the earlier submission I made, section 20. Section 20, my friend might have misunderstood me. Section 20 says what? Whenever the powers and function of a managing committee is taken over by the government, managing committee is not dissolved, but the power is seized by the government. In that eventuality, the section says that no, in that eventuality also, the service conduct of the employees which were.
See, there are two scenarios there. One is when the managing committee has been suspended. It is in existence but suspended, and the functions, duties taken over by the government. But the other part is that when there is no managing committee. Naturally, the school has to run. Somebody has to take over.
Yes.
And the government has taken over that role. In the role or function of a managing committee, action has been taken against you. So where is the illegality there?
My lord.
Except now we are not on that. Of course, as Mr. Bhattacharjee has rightly conceded, except to the extent of deprivation of your right to for natural
justice. Yes.
We heard and all those things. That is a different thing.
My lord will kindly appreciate one thing. They are the statutory authority, lordship. Any act done by them, it has to be authorized by the law, lordship. Law. That this is the law. Under this law, we have assumed the power and we can do the actions. Because it is not like an ordinary.
Yes,
they have to be guided by the law. And under which law?
So that is precisely what I am saying before this honorable court. Let me clarify the position.
Empowered. No. The power has to be specific. Because the ultimate authority is the managing committee. I was appointed by managing committee. I am the discharge of the management. Now.
Yes, I think we have to look to this aspect. Firstly, as to whether there's an alternative remedy like the tribunal for which you should approach. If that is not so, whether the action taken by the state respondent is within the rules or within the provision of law, that another aspect has to be clarified. So these are the two issues to be decided.
So far as the applicability of the RTE rules, I am not denying. That is applicable to all the schools.
So we'll see. If you're not denying, then we'll see to what extent it is applicable to you, and what in that context, what would be the powers of the state respondent.
I am on conduct rules, lordship. I am on conduct rules.
Understood.
This is different. Service rule is different, and conduct rules is different.
So how do we do it?
My lord is kind enough to grant me some time, my lord.
Yes, how
at least. May I pray for 2 weeks, my lord? Next date we'll finish it, whatever it is.
Are you still teaching?
Yes.
But not in the role of headmistress?
No, there is an stay order, lordship.
Oh, stay. So you're still headmistress?
Yes.
Otherwise nothing is affected, my lord.
No, but there is an stay order, motion.
What about the respondent?
Respondent number 7.
You're a teacher also?
Yes, he is
you're still teaching.
Only for the post.
So basically, as far as people would come approach the court if their pay or or where it comes to termination, all those things, maybe they would have a case where the court also has to look into it expeditiously. But in this case, it's just a question of power.
Yes,
just a question of tact.
That means.
But as far as functions are concerned, you are all teachers.
Yes.
So,
and law and there is no concept, lordship. There is no concept of promotion in aided school, lordship. Even the 1965 rules which govern for appointment of deficit or ad hoc, there is no such that saying that that based on the seniority.
Normal, my lord, senior most teacher is usually known as the head teacher.
My lord, kindly see that St. Anthony's College, St. Edmund's College, they are young principals, lordship. They are also aided, but not based on. We have that case, lordship, here also that Simit has saying that the matter travel up to Supreme Court, that says that post of the principal in aided schools is not a promotional post. That is not the issue, lordship, here.
Then why is he fighting, my lord? If that is the case, my lord, why is the petitioner fighting?
But for claiming that also he have to govern some rules after 15 years, because the law, the seniority and promotion, unless there is a rules, they cannot pick and choose.
Yeah, that will look into it. The matter has been heard substantially. Mr. K.P. Bhattacharjee, learned GA, has submitted that specific instructions is required from the concerned authority, particularly as regard the provision of section 24 or 20?
24.
24.
It is 24.
24 and the RTE Act 24.
Yes, 24.
No, not 24, should be 20.
In the RTE Act 20, no, RTE Act 24.
Oh, you're talking about the
Tribunal laws.
tribunal, where is it?
My lord, it is 20, my lord, as far as the rules are concerned.
Rule.
My lord, as far as the rules are concerned, it is 20, my lord. And my lord, the act would be
24.
Which provides for tribunals to
grievance redressal, my lord. That is 20, my lord. 20 of the RT rules of Meghalaya, my lord.
of Meghalaya.
Grievance redressal mechanisms for teachers for the purpose of section 24, subsection 3, my lord, of the main act. My lord.
This is one.
This I am referring to the rules, my lord.
But in the parent act is 24.
It is mentioned here, my lord.
Kumuntukan. Of Rule 20 of the Meghalaya right of children to free and compulsory education rules 2011. Specifically with regard to constitution of school tribunals. On consideration of the submission made, the same not be objected to by the petitioner. The state respondent is accordingly allowed to produce such instructions on next date fix. As prayed for, this is matter to 2 weeks. So,
Hello.